Well, good evening and thank you for joining us. Let me take just a couple of minutes to enter my information into the chat box. My name is Michael Gault. I'm an eminent domain lawyer with Bell, Carrington, Price, and Gregg, and we're here today for a virtual town hall. I'd like to thank any of you that join us here in the next few minutes for the live version. We always know that folks like to watch these later on as recordings at their own convenience. So if you're watching this at a later date, I certainly appreciate you joining us too. I am going to enter my name, my email, my direct line, and our team's email or web page for our eminent domain practice. So that should get you started with ample ways to contact myself and our team regarding this particular project and how we may be able to help in the future. And I'll touch on that as we get into this town hall. But if you're here joining us, whether live or at a recording at a later date, you know that we're here talking about the 321 Alternate Improvements Project. As with any project that any Department of Transportation does, when they go to widen roadways or improve intersections, that comes with a necessary evil of having to take what is currently private property in order to make that road project possible. That, in short, is what we refer to as the government's power of eminent domain. Put simply, that's the government's power to take private property for a public purpose. And long and short of it is that road improvement projects often fall within the definition of what is a public purpose. And so the government has the ability to negotiate for and to ultimately take private property in order to make sure that these road projects are completed. As with any other road project like this is under the umbrella of safety improvements, of site improvements, of traffic flow improvements, all things that we know are happening throughout the state of North Carolina, particularly in this area because of new population growth, new growth in general. And unfortunately, that impacts the landowners that currently own property along the frontages of this particular stretch of roadway. Now, what's important for you to know as landowners is that this process can be complicated, but there are folks like our firm who have experience, folks like our firm who only do eminent domain work on behalf of landowners, and we can help break down that process so that it's not so complicated. I'll go through that a little bit in just a second. The most important thing for you to know as a landowner is that even though the government has the right to eminent domain, and they can ultimately take property that they need to take for purposes like this, they have to compensate you fairly and adequately for what they're taking from you. That's what we refer to as the right of just compensation. That is your highest, most important right as a landowner in a case like this. And so even though the property that they claim they can take, they have to pay you for it. Now, that's again sort of where we come in. Calculating or determining what that amount of just compensation might be is again complicated. You can't just plug in A plus B equals just compensation, although oftentimes the government, in this case the NCDOT, would like to tell you that you can. That's not the case. We have a team of lawyers and staff who focus exclusively on representing landowners in cases like this. We can identify the damages to your property, not only those that are easily identifiable, but also those that you may not realize unless you're familiar with looking at plan sheets and looking at cross sections and thinking about potential impacts that may not show themselves until months or years down the road after construction is completed. But if you don't catch those particular damages at the front end, then by the time you settle the case or sign the settlement paperwork and take the check for just compensation from the state, then it's too late. You can't go back once you realize something may have been missed 2 or 3 years ago. Our firm has a practice area, our eminent domain practice area, and that's what we do. We specialize in identifying those damages. We help break down the process for the landowner. We are able to explain it to you from beginning to end in terms that are easier for you to understand, because unfortunately, most of you have never been in this situation before. You don't know the terms or the process or the procedure, the vocabulary, the players, but we know all of that. And so we're able to break it down into smaller steps so that even though it's unfortunate that you may be losing some property, at least it's not overwhelming when it comes to the entire process and procedure that's laid out before you. How does it work? Well, at some point when right-of-way acquisition begins, and we would expect for that to begin soon on this particular project, somebody's going to either knock at your door or send you a letter and let you know that they represent the department and that some of your property will be needed for right-of-way acquisition. They're more than likely going to schedule an inspection and an appraisal of the area that's being acquired on your property, and ultimately you'll be made an offer. Uh, at Bell Carrington, we like to be involved through all of those steps. So the earlier that you can get involved with us, should you choose to hire us to represent you, the better the ultimate outcome for the landowner at the end of the day. We're able to identify those problems early. We're able to explain them to the appraiser or to the inspector early. And so those problems are identified, they're noted, and we're not bringing those up in the 11th hour trying to scramble for a settlement for something that nobody's been thinking about for the previous 6 months or a year in a particular case like this. A couple of things that I like to highlight toward the end of these town halls. Initial consultations. I can give a lot of general information in a public forum like this, but independent one-on-one consultations will allow myself or someone on my team to be able to pull up your property in our software in real time while we're on the phone or a Teams call. We can zoom into your impact, and I can tell you with some specificity what the impact to your property may look like. Is it a small, what we would call a strip take along the front? Could it potentially be a total take of a residence? Or if it's a commercial or an industrial property, does the access change? These are just small examples of items or damages that we look for in any particular property. But it's very, very, very property specific. It's each independent parcel, each independent tract. And so we can call us. We're happy to talk to you free, no obligation, no pressure, nothing on your end that you're obligated to other than to give us a call, speak with us, help us identify your property. We'll help you identify the potential impact, and we'll tell you, number one, if we think you might need us, and number two, if so, how we think we may be able to help. The second question that I get often is attorney's fees. Folks wonder, is it worth it to pay a retainer or to be charged hourly? And at the end of the day, do those attorney's fees eat up whatever this firm may have helped me gain as far as just compensation from the DOT? Fortunately, at Bell Carrington, in our eminent domain practice, we've been able to develop a fee structure that's a contingency fee basis. Ultimately, our fee is a percentage of the amount of just compensation that we're able to recover for our landowners over and above the initial offer. And so that's a lot of words. It can get complicated, but it put simply, it means that there's no out-of-pocket cost to our eminent domain clients. There's no out-of-pocket retainer due up front. We don't bill you hourly. And ultimately, if we're not successful in identifying damages and increasing the amount of just compensation that you're going to receive, then you don't owe us any money out of pocket. Happy to explain how that fee structure works, how those percentages work per each individual type of property through those independent one-on-one consultations. Invite for you to send me an email or at bellcarringtoneminentdomain.com. There are 2 different ways there to reach out to schedule appointments. You can do a direct scheduling through a plug-in software that lets you put a calendar date in the future when it's convenient for you, or you can fill in a fillable form that comes directly to our team so that we can know to give you a call to reach out to schedule that consultation. See a couple of folks in here live. If anybody has any questions, I'll be glad to try to answer those. If you'd like to put them in the chat box, but again, sometimes people aren't comfortable with that or would like to do so more on a one-on-one consultation type level. And so feel free to send me an email directly, visit our website, fill out one of those forms. Feel free to give me a call. It's a little after 6 here this evening. Happy to speak with you this evening for a little while, or we're back in the office tomorrow morning, and somebody on our team would be glad to take your questions, look up your property, and to see how you may be impacted and if we can help. Wait just a couple of seconds here and not seeing any questions currently being typed, which is fine. Again, I want to thank you for those of you that have joined us live. I'd like to thank any of you that watch this recording at a later date. Again, Michael Gault with Bell Carrington. Our firm, my practice area within our firm, can help you identify this process, walk you through it, and ultimately make sure that you're protected financially from any impact to your property through projects like this in the future. So thank you for joining us. I hope you have a great evening. I hope you had a happy Thanksgiving.